Lankan Understanding, a media platform aimed at comprehending the path that Sri Lanka, an island in the Indian Ocean, has taken in the past, having enjoyed a very vibrant period and the potential for the future. The topic for discussion today is evolving laws, the procedure and the practice. We're indeed honoured to have with us the 43rd Attorney General of Sri Lanka, the 42nd Solicitor General and Judge Advocate of the Sri Lanka Navy, an alumnus of the Sri Lanka Law College, the University of Colombo and the University of Bristol. He is none other than President's Counsel, Rear Admiral Palitha Fernando. Welcome to the show, Sri Lankan Understanding, sir.
Thank you.
Thank you so much for taking time to join us. When we talk about laws and the evolving nature, and we go back in time, legal systems, laws and the legal practice have evolved over a considerable time span. When we go back to the earliest trends, could you highlight some of those milestones and how it was achieved back then?
Now, if you look at the law, George, you see the law has been evolved for the purpose of resolving disputes. Let's forget about all the niceties of the law, legal interpretations and all that. The law emerged for the purpose of resolving disputes among people, individuals and also others. So at the very earlier stages, the law was evolved by getting some person to resolve the disputes of the people. The earliest form of resolution of disputes, George, you might be surprised to note, is the show of strength. And Hugo Grotius, in his famous book on international law, he says that under international law, one of the legitimate means of resolving disputes is resorting to war. So the show of strength and using force for the purpose of getting your point of view through was the manner in which disputes were resolved during early times. Now, even if you take the primitive people, they also had a leader for the purpose of resolving their disputes. Now, this is why a leader was appointed, and in the leader they concentrated all the power, and the person was a person with some sort of strength, the person who enjoyed the confidence of all his followers, a respected person in the community became the leader in primitive society. So even up to date, we see that in such societies we get people resolving disputes of others, and those disputes are submitted to them. Now, this is the purpose of law. The law originated from that basic understanding. The basic reason is that it is there to see that disputes among people, individuals are resolved, and also to regulate activities of society. So whenever a legal principle arose, that legal principle arose for the purpose of resolving a dispute and regulating activities of society. As we go on, I will be able to show you that the laws are created for the purpose of catering to problems that arise in society. Some of these laws would never have been there if not for those problems in society. So as we look at the origin of law, we see that at all legal systems, all legal procedures originated from the basic idea of resolving a dispute in society. They took various forms as time passed, but what happened was this basic idea gave rise to the legal procedures, legal practices in various forms in different areas, but all of them were focused at achieving one objective, and that was the resolving of a dispute. That I can say is the origin of all these legal procedures that we will be talking about today.
When we talk about the kings and kingdoms that existed in Sri Lanka, there was such diversity. How were we able to evolve a system in which legal practice was accepted, understood across Sri Lanka?
Now, as we take Sri Lanka, George, I must tell you, we do not have a recorded history of established legal procedure in Sri Lanka during the times of the king. The king was all powerful. Now, king was the person in whom all people had confidence, and king was appointed following a particular procedure, and the king had all power. The power that we call executive, legislative and judicial in modern times were all powers of kings. So the king exercised that power, and for the purpose of exercising that power and for the purpose of implementing or regulating activities in society, he had his officials, and those officials in various areas at various levels, they implemented the law. according to what the problem was, the dispute was, it was referred to them, and then they looked at it in the way they were trained to do. They were not trained judicial officers. Now today we speak of mediation boards. Mediation boards are where you get a person respected or persons respected by society sitting there. They are not judges. They look at the problem and then try to give an equitable solution. And today in the modern world, even in Sri Lanka, we think that it is quite better than a judicial system, fixed judicial system. And if we can resolve these disputes outside court by way of mediation, today we have the mediation boards, it is considered extremely necessary and good also and effective also. Now this is the system they had those days. Those days there were officials appointed by the king at various levels, and sometimes it was the chief priest of the temple, a respected individual, and the people went to him with their problems, and he gave his solution, and the people always respected that solution, whether it was for or against him. Now this is the manner in which the kings exercise their power for the purpose of exercising their judicial authority. But however, the king was the ultimate court of appeal. All problems went to the king, and even there was a right of appeal. If you read Robert Knox says the manner in which these matters were brought to the king, and the king looked at them and the king gave the ultimate solution. But all the serious offences like murder, robbery, there were offences like that, they were decided by the king and the king's court. And the king's court looked at the problem. There were no legal procedures, there were no fixed laws, but then there was something that was accepted by custom. All those are customary principles of law. As we know, in England, the common law of England is also based on customs. Similarly, we also did have customs, and society accepted them. Society knew that they had to follow those, and that was the way in which they dealt with this problem, even in a diversified society.
Amazing. And so when we come back, we will be speaking about legal systems, lawmaking and laws that evolved during the period of colonization and up to the period of independence. When we return with the Sri Lankan Understanding with our guest today, President's Council Rear Admiral Palitha Fernando. Welcome back to the Sri Lankan Understanding. We are in conversation with the 43rd Attorney General of Sri Lanka. Sir, when we look at the period of colonization, and we know that we had 3 colonizers coming into the country on a large scale, and they brought their own laws, legal systems, and means of execution of these laws. How was adaptability at the time? What impact did it have on Sri Lanka?
Now, if you take the Portuguese, they came to this country in 1505. They came to Corte and they had some sort of influence over the king, the Sinhalese king in Corte. They were not interested in introducing their legal systems into this country. If you look at the history, you see that the Portuguese did not introduce any laws. What they were interested in propagating their religious ideas, Roman Catholicism and all that, and they propagated their religious ideas into society. That was the first impact they had. Then we speak of the Dutch. When the Dutch came into this country, that is where we see as a turning point. The Dutch came into this country with the Roman Dutch law, and they established the Roman Dutch law in this country. And George, that is the first time we see in history an established court system. The Dutch established their court system, and one court in Colombo, one in Gaul, and one in Jaffna for the purpose of enforcing the law. And they also had the rules, the Roman Dutch law rules. From Justinian's code under the Roman law, they brought in those things and they introduced the maritime provinces of this country. And also they wanted to codify. Now, as you very correctly said at the beginning, there were other religious laws and also diversification was seen. And in those instances, the Dutch did not want to force upon the people their laws. They codified the Tesavalami law, the law of the people of the Jaffna province. And also the religious laws of the Muslims, they codified them as much as they could. But unfortunately, with respect to the Sinhala laws, the kings of the Sinhala kings, they were so diversified, and there was no certainty in certain areas, that they did not codify that. Instead, they introduced the Roman Dutch law as the law in the maritime provinces, and when the British came to this country, the law that was enforced or implemented within the maritime provinces by the Dutch judges were the Roman Dutch law principle, and that is why the Roman Dutch law came into this country, and up to date Roman Dutch law is considered the common law of this country in those areas. Now then we speak of the British. In 1796, when they ousted the Dutch and they took over, they have a policy. Their policy is that they do not disturb the prevailing law in their colonies. If they colonize, then they let the laws in that country at the time of colonization continue. So they let all these laws, the Teeswalame law, the Candian law, then the Roman Dutch law that was there to continue. And that is why we have the Roman Dutch law still in this country. There was one law that they did not want to continue with, that they abolished. And if you look at the penal code, the penal section 3 of the penal code says that all criminal law that is in force in the country is from this date abolished. Why did they do that? According to lots of people, they did so because they found the criminal law of this country too harsh. The punishments that were inflicted were too harsh. And I think you should read Robert Knox, George. Robert Knox says that when a man was caught, and before his execution, he was taken around the city, garlanded, and then he was taken to a place where he was executed, and there were trained elephants who pulled out their limbs and threw them aside and crushed them, and dogs were so used to it, and dogs used to go and pounce upon the dead bodies. And when a man was taken around garlanded, dogs knew that this man is to be executed, and the dogs pounced upon him while he was walking to the place where he is to be executed. So the British thought that these laws are a bit too harsh. As a result of that, they brought in the criminal law of the United Kingdom as the criminal law of this country, and up to date the penal code of this country is the criminal law. The criminal law, the English criminal law, which was introduced by way of the penal code. But up to date, the personal laws are the Muslim law, the Teeswalame law, and the Roman Dutch law. Personal laws means the laws that deal with your family matters, marriage, then your testamentary matters. All those matters are called personal matters, and personal matters are dealt with according to the laws that prevailed at that time. Up to date we have the Teeswalame law, up to date we have the Muslim law, up to date we have the Roman Dutch law principles. However, certain things have been now changed. British brought in legislation. For example, the marriage registration ordinance. Now if you take the Candian law, those people to whom Candian law apply, they can marry under the Candian law. Their divorce is under the Candian law. The Muslim law, divorce is under the Muslim law. And the rights of the wife under the Teeswalame law would be the Teeswalame law. You might be surprised to note, George, that under the Teeswalame law, even today, a wife cannot sell her property without the permission of the husband. That is because that was a personal law that prevailed for generations, and that personal law continues up to date. So with the colonization, what happened was, there was the establishment of the Supreme Court, of course, by a royal charter in 1801. In addition to that, the British introduced certain laws. Those laws are their procedural laws, and other laws are still there, replacing the Roman Dutch law principles that prevailed up to that time. Other than that, we see that colonization did not have a very great impact on the laws that prevailed at that time. It is only thereafter, little by little, we see the English law being introduced, and up to date those changes take place.
When we come back, we'll be talking about the legal systems from independence onwards and where we're going in the future, when we return with the Sri Lankan Understanding. Welcome back to the Sri Lankan Understanding. We are in conversation with President's Counsel Rear Admiral Palitha Fernando, and we are talking about evolving laws, the practice and the procedure. When we look at the period from 1948 onwards, Sri Lankan leaders had the choice of making their own decisions. Power had now been transferred to Ceylon. At this point, what change did we experience? Also, when we look at the impact it had on Sri Lankan society, now that we had the opportunity of making our own decisions.
In 1948, George, with the Salisbury Constitution, the constitution that was promulgated at that time, the Independence Constitution, that had one section, Article 29, which was aimed at protecting minority rights. But that constitution continued from 1948 up to 1972. In the year 1972, there was a constitutional revolution that took place in this country. Because in terms of the 1948 Salisbury Constitution, if the constitution was to be changed, then there was a procedure that we had to follow. We did not follow that procedure. Instead, we went before the people, Mrs. Sirmavu Bandaranayake and her party went before the people and sought a mandate from the people to change the constitution without following the procedure laid down in the Salisbury Constitution. In fact, Mr. Sundaralingam went to court and challenged it. And there was a case filed asking for a writ of quo warranto, that is asking what authority do you have to act in this manner. But the court did not grant relief in that case. And we met, in fact, it was not Parliament that changed the constitution. I don't know, George, whether you can remember, but it was a Constituent Assembly which met the Navarangahala for the first time. And then the Constituent Assembly adopted the constitution, and then we became a republic in 1972. In 1972, the Republican Constitution broke away from the British tradition and then established a system under the 1972 Constitution, which is called the first Republican Constitution. In 1978, we brought in another constitution, that is the constitution which is in force up to date. Now, under that, we had many things that we can talk of. One is the fundamental rights chapter. Though the 1972 Constitution recognized fundamental rights, there was no law enforcement machinery. But the 78 Constitution has given us an enforcement machinery. Then we brought in an executive president system. Now, when we speak of the executive president system, George, those days king was all powerful, all power was concentrated in the king. But later that power was given to a parliament of selected representatives. But today we have gone back and concentrated some powers in one individual, that is the president, but that was done in order to make the economic progress more meaningful, according to President J.R. Jayawardena. So we have come all the way from 1948 up to this point. And what we have done is we have made our hands strong in order to deal with the problems that arise. And as a result of that, up to date we get this constitution, the constitutional changes for the purpose of dealing with all the problems that are before us. We have established provincial councils, we have brought in the 13th Amendment. By the 13th Amendment, we have devolved power, because power devolution was something that the minorities were asking for. Under the Salisbury Constitution, Article 29 was very strong, which was against any sort of discrimination against the minorities. So now with the 13th Constitution, we have gone ahead and we have devolution, we have the provincial councils. So that is where we stand right now.
No doubt we faced several challenges along the way in terms of evolving laws and how we adapted to them. But when we look to the future, when we look at how the world is evolving, are we seeing a similar system of evolution taking place within Sri Lanka? You talked about some of the British laws or the laws that were brought in by them in terms of the criminal code. What kind of evolutionary process are we seeing in terms of responding to the 21st century? Britain has changed some of these laws. Other countries which also had them have evolved since. How are we progressing?
George, about that I must tell you, I feel a bit sad because in 1973, we brought in administration of justice law. And administration of justice law was totally new. Earlier we had the Code of Criminal Procedure, but we did not follow the Code of Criminal Procedure. We abolished it and we brought in an administration of justice law in the year 1973. That was a totally new law that was brought in. They looked into it very carefully. A panel was appointed, and then the administration of justice law was totally different from the Code of Criminal Procedure Act. But unfortunately, in 1979, we abolished that law and then went back to the British law. So up to date, it is a British law. You read the evidence ordinance. In terms of the evidence ordinance, if there is any issue which is not answered by the evidence ordinance, what are we supposed to do? Look at the English law and then follow the English law. Up to date, that provision, section 100 is there. So we have not thought in terms of going into the future, thinking in terms of what is good for us. Today, the world has improved and advanced technologically and scientifically. As a result of that, scientific and technological advancement should be taken into consideration. In a way, the COVID pandemic has served us, because today we have online proceedings. In other countries, court proceedings online was simple. Those days they had it. When I went to Australia several years ago, they had it. In our country, we used to bring all accused to court, but today we have gone online, and I think that is a good point for us to start. We have to look into the future. We have to try and do things that will serve us better with the modern world. We can't stand as silent spectators when the world is moving. Our law has to change, and the change should be a change for the better. We should take into consideration our cultural and social practices, what our people want, and then our law should proceed in those lines. You know, I can remember once Mr. Tony Blair, Prime Minister of India, said, the health service of this country should be what the patients need, and the education system of this country should be what the students and their parents need. Therefore, we have to look into what we need and then evolve our laws in order to achieve those objectives. I hope that will happen very soon. We have taken a step in the correct direction with this pandemic, and we have now started our online court proceedings, and that is working very well and expeditiously. So we should think on those lines and try to do better in the near future.
Thank you very much, sir, for that very lucid explanation of how law has evolved from then to now. And as you very rightly said, we cannot be silent spectators. The world is surging ahead. Societies are surging ahead. People are doing the same. It is time for Sri Lanka to also take her position amongst countries of the world on the international stage as a country that has not only enjoyed a very rich and diverse past, but a country that also has much potential for the future. And that is exactly what we try to focus here on the Sri Lankan Understanding. Thank you very much, President's Counsel Rear Admiral Palitha Fernando, a person who has not only been involved in the practice of law, but also in the teaching of law for several decades, having even taught myself many years ago. Thank you so much for joining us on the Sri Lankan Understanding, and thank you for being a part of this session as well. Join us again as we take up another topic concerning the island of Sri Lanka, its past, its present, and the potential for the future.